What was the relief sought by the
Yes,
petitioner?
Lordships. Now, what has happened in this case, Your Lordship, that the OP number 9 and 10, they filed a.
What is the relief sought by Rudal Sahani and others in the writ petition?
Lordship, this LPA is arising out of the writ petition filed by us, Your Lordship, by Jagannath Yadav, Rudal Sahni and others, Lordship. The relief is that we sought quashing of the order passed by the DCLR, by which he has decided the title of the land and has directed the CO to hand over the possession of the land in question to the OP number 9 and 10. This is the relief, Lordship.
Oh, writ is maintainable in so far as land dispute?
Lordship will see that the application was filed under the BLDR Act.
Huh?
The application before the DCLR, it was filed under the Bihar Land Disputes Redressal Act. It was filed, Your Lordship, and then before the DCLR decided the issue.
No, issue is the title, no.
Yes, he should not have decided, Lordship. He should not have decided.
But, therefore,
But he decided, Lordship.
Huh?
But he decided. This is a. But he decided. He ought. Yes, Lordship. That is Annexure 1. Annexure 1 to the IA number 1. Page 56, Lordship. If you Lordship will see page 57, then the 57.
yes. What date of this order?
Date of the 15/7/2013. Reading is on the top, Lordships.
Order signed on 2nd of July 2013.
Yes, Lordship. Those are. It has been issued wide memo, Lordship, on 15/7.
Who is appearing for state?
ऊपर में देखा जाएगा फर्स्ट पेज के on page 56 on top it is 15/7/2013. It has been signed on itna.
Could be decided by the DCLR?
My lords, there is a provision under section 9 of Bihar Land Tribunal Act. My lords, application is maintainable before BLT, my lords.
Huh?
Bihar Land Tribunal.
It is that act.
नहीं है भैया
Bihar Land Tribunal.
Lands Tribunal Act is saying, Lordship, it is not there.
Yeah, BLT, it is 2009.
हाँ.
Nice. It's evening.
Nonetheless, my lords,
सारा excellent का. Excellent.
Lordship, the BLDR Act is not included.
my lords, initially it is a matter of mutation, my lord. And
See section 9.
my lords, relief was sought for in court below, my lords, for mutation. For mutation, my lords.
Mutation. Mutation is required to be entered. Such application was presented before the revenue authorities.
My lords.
Then
Amendment number 9 and 10 initially applied for their names for mutation, my lords, and their application has been allowed by the authority concerned.
allowed by whom?
My lords, DCLR.
Deputy, what is the district collector?
Reforms, my lords.
And diffusion.
Deputy collector land reform. Ultimate.
On what date he has, on what date he has entered the mutation in the name of petitioner?
My lords, memo of appeal is totally vague, my lords. I fail to understand.
Sir, give the date, sir. We will decide the matter.
No impugned order annexed with my lords. I have no impugned order. Only I, in memo of appeal, my lords, only learned honorable single judge has been annexed. Kindly see memo of appeal, my lords. I fail to understand what
Yes, sir. Yes, madam. What is the date of deputy collector's order insofar as mutation entry?
Lordship, the mutation has been done in the, we have, the opposite parties, Your Lordship, they had not,
Answer to the court question. What is the date of
my lord.
2012-13, Lordship, we have not mentioned, Lordship, for,
date?
2713, my lord.
15/7/2000.
15/7/2000.
Lordship, this is not the order of mutation. That is why I'm just explaining to Your Lordship.
Ah.
That the order passed by the DCLR is not the order of mutation.
Where is that order?
Of mutation.
No, according to you.
That is Annexure 1 to the IA, Lordship.
Annexure?
Annexure 1 to the IA number 1 of page 56. This is not the order of mutation, Lordships.
Appeal. No, appeal against which order?
Mutation order.
She said. What is the date of mutation entry order?
15/7/2013.
ये mutation नहीं है.
Limitation नहीं है.
No, in the annexure 1 there is no reference.
Which order was challenged before DCLR?
Lordship, I have not challenged. That is why I'm just trying to explain,
You may
Lordship.
not challenge here. What was the subject matter before the appellate authority?
Lordship, the
My
before
lords, kindly see paragraph 3 of the memo of appeal, my lords.
Lordship, the respondent number 9 and 10.
For mutation, my lords, and ultimately appellant file appeal.
What is the date of mutation entry, sir? 27 is appellate authority's order.
My lords, memo of appeal is totally vague. I fail to understand what is the case of appellant, my lords.
Lordship will see page 57, bottom of the last 4 lines, Your
Last
Lordship.
4 lines.
The respondent number 9 and 10 moved
DCLR
before the
order.
DCLR for declaration of their title and for handing over of possession, Lordships.
It is not mutation.
It's not, the dispute doesn't arise from mutation, Lordships.
My lords, why not he is annexing all impugned order before the honorable court, my lords? Even before the honorable
57.
single judge, my lords.
Page 57, bottom last 4 lines, Lordships.
Page 50 last. Have fun. कितना था बिल दे रहा हूँ DCL का पेज नंबर
मेरा
पेज
Or shall be Hold on. Writ petition. Provision is there? No, the order 272,000 to collector. What order? Against the deputy collector. Yes.
They went to the commissioner for.
There is a commissioner order. They have not challenged.
We have not gotten it on record. Either we have got on record the provision which can be done.
What's the-
I think we'll give them the script which was brought by the prosecutor.
On technicality, we will but the matter. We'll give you liberty to file fresh petition.
Lordship, I'll just take few seconds and say that.
Madam, please, the single judge has rejected the petition for want of impugned order. Then what is wrong in it? What is wrong in it?
Lordship,
Why we should interfere with that order?
Lordship will further see that the,
Appeal is provision is there.
yes, there is no,
According to him, there is an appeal provision.
no,
We are
Lordship,
giving liberty, no?
yes, Lord.
Remanded
Lordship, remand before the
to single.
No, you have to file fresh petition, writ petition,
press writ.
producing the impugned order and whatever you want to urge.
Lordship, let's submit only one, if I am permitted. See, actually, if your Lordship goes through the provision.
Sir, we are only on technicality, not on merits. What is wrong with the single judge order?
Single judge order wrong. What?
Lordship,
Lordship.
Correct, what is wrong?
Am I permitted? One second. Actually, what has happened that we filed the order, but it was not legible. DCLR order he wanted to see. So I prayed the Honorable Court to call for the records. Because in the record, original record, against which we had come, the DCLR order was there. But the single judge,
If that is the case, show
but
from the writ application, which is the impugned order.
single judge said, actually single judge was of opinion, no, I will not call for the order. What I will do is, I will simply reject, you go to LPA. But here, the question is if...
Sir, show us from the writ application that illegible copy has been furnished.
Actually, illegible copy was there, but only thing is that
From the writ application.
I did not file illegible.
Why you want say?
I prayed to call for the records, but it was not called. Here, Lordship, only one point I would like to just tell. Only by the Lordship one order, the problem will all be permanently resolved, if I am so permitted. Madam is, I will listen. If your Lordship goes through the BLDR Act, that is section 4 and 5, it is very clearly written that the DCLR cannot settle a title.
You can't decide the matter on merit.
Because it is not mutation.
LPA is limited. What is the error committed by the learned single judge?
Actually, there are two. There was another order earlier in which actually we were directed to go.
We are not concerned with that. Earlier order and all. Present order is simple. Two things. Single judge has said that the impugned order has not been furnished and he have a remedy before the appellate authority. That's all.
It could be remanded straight to the civil court as per the provision. Provision is there.
No, why we should
Title dispute because in the provision it is there. In the provision.
You go and make such a submission while filing fresh writ petition before the single judge.
Lordship, may I submit that it may be remanded before the single judge where we'll furnish the.
No question of remand.
Because
No question of remand. Because of a mistake committed by the petitioner, why we should entertain and remand the matter?
Lordship, the petitioner will suffer the
What suffer?
already.
No, petitioner counsel must be subjected to consumer forum. Deficiency of service. Simple thing, impugned order is not produced.
Impugned order produced किए थे जो जिससे arise किए
ये नहीं ना DCLR order.
Actually, there were two. Lordship, I'm sorry. Actually, there were two impugned orders. One was the order of the court, earlier single judge. He directed that you file a writ. His Lordship has order, and that order was actually impugned, and that's what we have annexed. But he said, no, DCLR, since also you have challenged, you should have also given DCLR's order, and that's actually we have not annexed. Got my point?
How?
It has so happened. I'll explain. I will.
Another single judge.
He has remanded. See the order. See, kindly see the attached writ. The
I have-
connected writ में हजूर देखा जाएगा.
Sir, in your prayer,
Connected.
in the writ application is challenge to the order dated 2/7/2013 passed by the fifth respondent in land dispute resolution case number so and so. That's all. And further, you have sought for various directions. Yes, sir. The presenter LPA is filed against the order of the learned single judge dated so and so, passed in CW. Prima facie, the present LPA is not maintainable for the reasons that CWJC has been decided by the learned single judge. In not producing the impugned order in CWJC, and further he has taken note of that the petitioners therein had remedy of appeal before the appellate authority. Remedy before the jurisdictional tribunal in filing appeal. So next, we find prima facie there is no error committed by the learned single judge so as to interfere with the order of the learned single judge dated 15/1/2019 passed in CWJC. So, however, in the interest of litigants, they are at liberty to file fresh petition or they are permitted to invoke other remedies if any. With these observations, the present LPA stands dismissed.
Lordship, may I submit? To the extent that there is no provision, we have filed the appeal before the committee.
Whatever you want to say before this learned single judge.
Same order in the next case.
Your Lordship has held that that part is also correct. That is why, Lordship, I am submitting on that point. That we have filed the appeal before the commissioner and that was dismissed for default. I filed the restoration petition, that was also dismissed, and that was also assailed in the writ petition. And to that extent, the Honorable Single Judge has held that they have the remedy of appeal, against which there is against the order dismissing my restoration application.
Sorry, madam. Yes, next
There is
case.
Order, my lord.
Same order.
Same order.
Same order.
Same order.
If we file, could I seek a permission? If we file, it should be listed within shortest possible.
Why?
Because
First of all,
Go to call-
look at your conduct. Petitioner counsel conduct.
it should be listed. Okay, Lordship, whatever your Lordship are.
Serial number 3, Pankaj Kumar versus the Bihar Public Service Commission through its chairman for the Shri Amresh Kumar Agrawal.
My Lord, may kindly have a look at the order dated 14/11/20.
Lord, pursuant to my Lord's last order, we have brought the copy of the said subject.
He has put his not against the revised. Paste. Yeah. 45. The question. Oh, in this is no page. Question. Petition. Okay. The altered acts here initial is required to be.
He also put his signatures. His approval is also given. In some cases, if he has touching. He made alterations without any initial, not in signature.
At the best,
Petition by the question in the first place. Here,
Petitioner Council says that as initial is required.
But not possible without problem. We used to or they simply like this.
इसमें कुछ है
Section 41.
correct. He has to follow certain procedure. No?
That must be somewhere else. It is on
Who is for BPSC? What are the direction manual for the examiner and head examiner? Where it is?
We have, Honorable Supreme Court has dealt with.
First answer.
Yes.
If you don't have, you say that we don't have, we have not given any instruction.
This is not on. This is not on record.
Not on record, no. That means it is in your office.
No, but not that was.
Sir, have you prescribed or issued such a notification
Yes.
to the examiner or not?
Yes, yes.
Show us.
So,
Show us whether has he followed or not. That is we wanted to verify.
Lords, I will produce that. I will produce that. If that is required.
Sir, bring that.
Because that issue, my lords, in fact, the similar issue, my lord, was also earlier considered with respect to this very exam. Same issue. My lords, ultimately the matter, even division bench upheld that. We have annexed earlier orders also.
Same issue arose in that case of
Same examiner and head examiner. Same batch 53 to 55.
You are having that judgment?
Yes.
Yeah, that is part of the
Yes.
annexure.
Read out that paragraph.
That was with regard to, I'm sorry.
My lords have asked for Supreme Court judgment.
Whichever judgment you please pass on,
Supreme
read the relevant paragraph. We want to verify whether the present matter is identical to that of other matter or not. If it's identical, it is case.
My Lord, annexure A series to the counter affidavit. My Lord, that is CWJC number 1137 of 2014.
Where is the order, sir? When you are relying on some judgment or order, is it not necessary?
Lord's judgment that has been annexed along with the counter affidavit. My friend is referring to that judgment.
No, we were
Along with the counter, nothing is.
In the writ proceeding, my Lord.
Counter in the writ.
You should say so, no? Merely counter affidavit means
Ordered.
is it Prabhat Kumar case?
Yes, yes, my Lord.
Which is the relevant paragraph?
My Lord, this relates, it starts, my Lord. Petitioner is one of the persons who sat for 53rd to 55th Common Combined Competitive Exam held in the year 2011.
This also is here the
They
petitioner.
are not concerned with the relevant year and this thing. We want to know whether examiner is required to put his initial at the relevant alteration of marks or not.
My Lord, in the
To
count,
that extent,
That-
the judgment is covered or not.
that has been dealt with, my Lord, by the Honorable Single Judge in that internal page 3, my Lord. In the counter affidavit filed on behalf of the BPSC, they have explained the position by denying that there was no any wrongdoing or hanky-panky. The overwriting is in the handwriting of the examiner.
No, we are not.
We are not concerned with the overwriting. We are concerned with the non-initial, putting initial against a revised marks.
बढ़िया
My Lord, I'm going to that. But the marks was reduced by the examiner. The examiner was confronted with this position after showing answer sheet of the petitioner, and the person gave in writing before the chairman of the BPSC that it was a case of oversight, that initial against overwriting was not put. The reduction of marks awarded to the petitioner in the 3 questions were done during the course of evaluation itself. The final tally of 121 marks is reflected in the award list. There is no cutting or variations in the marks of the present petitioner along with other candidates in the award list.
In the division bench, there is no waiver of putting initial against revised marks. Read the division bench order. Having heard learned counsels for the parties.
Yes, we find no merit in this.
Please read.
No doubt there is some changes of marks, that is from 26 to 24 in respect of question number 1, 2 and 9, but the total marks given by the examiner negates the arguments raised on behalf of the appellant. In figures, the total marks is mentioned 121 and in the words 121. There is no overwriting or interpolation with the marks. Or are written in words.
On the other hand, in the present case, issue is, we are repeating for the third time.
Yes.
In the present case, issue is whether examiner is required to put his initial against the altered marks. Not in the main page, altered marks.
Head examiner, if head examiner has altered the marks, then he has to put his signature. Even the learned single judge in the writ proceeding has.
Signature is on the main sheet. We are asking you signature on the relevant marks.
Yes, relevant marks in the front page of the.
Not front page, sir.
As well as in the internal page of the question.
Internal page, has he put?
Yes, he has
Yes.
put, my lord.
But here it is not there. See.
In one place that.
Sir, you please see, sir.
Let's say the first page of this copy also bears the signature of the.
Sir, that is the reason we are asking you.
Lord,
What are the instructions given to the examiner and head examiner? What are their duties?
Lords, please kindly bear with me for a few minutes. What I am trying to, that my lords, even if the head examiner, my lords, inadvertently didn't put his initial with respect to reduction of marks with respect against any particular question, but if ultimately on the first page the total marks, my lords, this candidate as per the examiner had secured 149. Now the head examiner, my lords, reduced 2 marks, 3 marks in total 9 marks. So it came to 140. Now the first page of the answer sheet, my lords, the total marks is there. There is, and that bears the signature of the examiner and head examiner also. So, in the earlier case, which might just now have been placed, even the division bench has said, yes, there are cuttings or that has not been signed. But the first page, please.
This could be resolved.
Yeah.
We have given instruction to the head examiner and head examiner. What are the instructions given to the examiner and head examiner? Where is that?
My lords, I said on the first line itself that is not on the record. I can produce this.
All right, produce, sir.
Yes, though.
That has been. That has been dealt with the Honorable Apex Court, my lord. This
Sir, produce this, the instruction given to the,
Very well. If you want, the court wants, I can produce that.
yes, we
In
want,
first line, I said
We want-
the record.
we want, that is the only issue here.
Yes, we will produce that on the next day. But ultimately,
Pursuant to the order,
and secondly, my lords, one thing more also is there that
the order dated 14/11/2022, the BPSC have produced a sealed cover, sorry, answer script of the in a sealed cover, and the same is opened in the open court and verified with revised marks awarded against relevant questions by the examiner has not been initialed. On the other hand, facing sheet where the total marks, total revised marks has been carried out, has been initialed / signature is forthcoming of the head examiner and examiner both.
Yes.
Examiner and head examiner to stop. Therefore, it is necessary to have the benefit of notification or order so far as powers and functions assigned to examiner and head examiner. In this regard, instructions given to the examiner and head examiner by the BPSC is necessary to examine as to whether examiner who has revised the awarded the answer sheet and awarded marks is required to be initialed by him, or head examiner is required to be examined with reference to the instructions given to the examiner and head examiner. To stop in this regard, the BPSC is hereby directed to produce instructions given to the examiner and head examiner as to how they have to function in respect of evaluation of answer script. Is this matter 2 weeks? Court master is hereby directed to return the answer script of the petitioner in a sealed cover to the BPSC council during the course of the day. The answer script shall be brought on the next date of hearing.
The hearing for Orders of Office was given before the Vice Chancellor versus Dr. Prabhakar Bhatt for the appellants Mohammad Nadeem Siraj.
How he is arguing on that point.
By order dated 8/12/2022, your lordships was pleased to issue notice.
Await service of notice to number 2 and 3.
2 and
1, 2.
1
1 within bracket 2i and 1 within bracket 3i. List this matter after 4 weeks.
Case number 5, Shobha Prasad versus Bandana Sinha and others for the appellant Sri Anurag Saurabh.
My lord, praying for 1 week adjournment.
My lord has seen this.
What is the defect number 3? Defect number. Where are the defects? Okay, the application. Heard by Shobha Prasad. RT. Now, why are you asking time?
My lord, due to medical emergency, arguing counsel is out of station, my lord, for his treatment for his father.
It's required to file a document.
Yes, my lord, due to medical emergency, he is out of station, my lord.
Is to establish vested right to.
Appellant is not party to the proceedings. Not maintainable. They have already recorded on what day? For the when council Mr. So and so seeks time. It is made clear that no further time would be granted on the next date of hearing. Release this matter next week. Come up. The LPA is by the third party.
Serial number 6, Naval Kumar Meena versus the Union of India for the petitioner Sri Ranjit Kumar.
Wait for 1 week time to remove the defect, Lordship, as the file was not available in the section office.
It is defect free or something?
Still under
Defect free is there? Further objection is there?
defect free है.
What is the subject matter?
Lordship, this matter is related to the CAT appointment in the railways, Lordship.
Appointment?
Of Group D post in railways, Lordship. The matter is related to that, the appointment.
This matter next week. Please don't ask time.
Lordship. Pleasure.
Under the heading for order serial number 7, the Union of India versus Manish Chandra Roy for the petitioner Sri Sujit Kumar Sinha.
In this case, twice time has been granted, my lord, but by mistake, the reply has not been received, my lord. And therefore I pray that I will file my reply.
Last time also you have taken time.
Yes, my lord.
On 15/12.
Yes, my lord.
It is almost 1 month.
It was by mistake, my lord, that it has not been sent by me, my lord. It is my error, my lord.
Then
And,
you dismiss.
My lord, then your lordship on merit hear the matter, my lord. I will my main argument only on the basis of the tribunal order. my lord.
3/11/2022 also, your lordship, there was some order.
I will argue only on the basis of the tribunal.
No question of argument. We will dismiss simply.
My lord, the lordship permit me, my lord.
Order dated 17/11/2022 is not complied. In fact, on 15/12/2022 also Time was extended till today. Even to this day, there is a non-compliance. Accordingly, matter is urgent to 2 weeks, subject to payment of cost of rupees 5,000. Cost shall be remitted in the High Court Legal Service Authority.
It is my mistake, Lord.
So what? You have any privilege?
Then I will pay the same, Lord.
So you have to pay. Please don't mention who has to pay and all. The petitioner has to pay, that's all. It is not for the first time. In November it was urgent to December. Again December to January. Now January to February. What is this?
On 3/11 also, Your Lordship, the cost was imposed for certain.
Huh?
On 3/11/2022 also the cost was imposed. My lords.
They may be rich.
Serial number 8.
The respondent is a Group D employee.
Not true. He's not in employment, Lord. He's seeking employment because of Your Lordship. It is being delayed despite having a order in your.
Cost shall be paid to the respondent. Instead of High Court Legal Service Authority paid to him.
Yes, I will pay to you.
Serial number 8, Union of India through the Secretary versus Siddheshwar Kumar Jha for the petitioner Sri.
In the morning, I had prayed for let it be taken over the coming Tuesday, Your Lordships. For learned AG to assist Your Lordship in this matter.
Right. In this case also subject to payment of cost.
Your Lordship, we had the paper service book. Last order of Your Lordship will peruse it because there was no.
Last time order is at the request of the Land Council.
Yes, after previous to that, Your Lordship.
Previous that the order asking you to produce the service
book. In fact, we had the service book. We have returned it as an abundant precaution.
Don't give any explanation. Just take down. For non-compliance of the order dated 10/11/2022, read with the 8/12/2022 order. The petitioner have failed to comply the order dated 10/11/2022. So Land Council for the petitioner seeks time. So time is granted for a period of 2 weeks.
No, we don't want 2 weeks, Your Lord. Let it be coming in the coming week, Your Lord. Maybe on Tuesday onwards.
Next week, subject to payment of cost of rupees 5,000. Cost shall be remitted, paid to the respondent Siddheshwar Kumar Jha.
So I have to pay it through his council or
his council / council.
Serial number 9, the State of Bihar versus Surya Singh Sahu for the petitioner Sri Sanjay Goswami.
Lord, if Your Lordship permit, my Lord, this matter can be taken up, my Lord, after 12 minutes. This matter can be taken up, my Lord, after 12 minutes.
Why?
Lord, Mr. K. Verma Senior, AG3 has to argue in this case.
After a few
Perhaps, my Lord. Oblige.
Serial number 10, sorry. Serial number 11, Rohit Nandan versus the Union of India for the petitioner Sri Ram Shankar Raj.
My Lord, on previous day, direction was given the Union of India to produce, my Lord, exhaustive counter affidavit, supplementary counter affidavit, supplementary counter affidavit has been filed.
I have filed today before.
File it in the registration. The respondents are permitted to file supplementary affidavit during the course of the day in the registry. Release this matter next week.
सबको कॉपी दिए
Kiran Bhattal, Raj Kishore versus the Union of India for the Business.
बात कहाँ फाइल कर रहा है?
May you please reply. Lordship, Central Administrative Tribunal has totally failed to consider the case of this petitioner. Petitioner never prayed for questioning the promotion list, my lord. Lordship, petitioner prayed only for quash the memorandum or modify the memorandum which is issued by the Senior Divisional Personnel Officer, Eastern Railway, Malda Bhagalpur, my lord, which is issued in the month of June 2016, my lord, which was for a fixation of all those promoted staff, my lord, and the name of petitioner was left because on wrong pretense that he was not assumed the charge of promoted post, my lord. In fact, he worked on the promoted list from 2015 to 8/7/2016, my lord.
Where is your OA?
Lordship, Annexure 2 at page 19 is, my lord, promotion. Yes, my list is promotion list, my lord. And
Where is the OA original application filed before the CAT?
Yes, my lord.
Where is that?
It is annexed, my lord.
Correct. Where is? In which page?
I have correct the page, my lord. It is from the. It is from. '44, my lord. From 44.
Promotion to which post? Technical 3 FCO.
G, FCO.
From which post?
Theater, class 3, my lord.
Plus 2. Huh?
Class 3, my lord. Class 3.
Class 3. Where is the combined seniority list of class 3?
No, my lord. Departmental promotion, my lord.
Correct, sir. For the purpose of departmental promotion only, they have to prepare the feeder cadre senior.
Feeder come operator, my lord. Feeder come operator, my lord.
Your respondent.
My lord.
Where is the seniority list?
No, I have to file a reply, my lords. And my lords,
And council,
apart from the mail,
and council for the Union of India is hereby directed to Union of India dash concerned department is hereby directed to furnish a method of recruitment to the post of technical dash Roman 3 F.C.O. Comma. If it is a promotion, if it is to be filled up by means of a promotion, in that event, feeder cadre combined seniority list, so as to ascertain as to ranking assigned to the petitioner, and further his junior has been promoted to the aforesaid post or not. Full stop. The supplementary affidavit must also contain as to why the petitioner name has been overlooked for promotion to the aforementioned post. Release this matter after 3 weeks. It is made clear that no further time would be granted. Basic, they are not part of the.
The heading for admission serial number 13, Lalu Prasad versus the State of Bihar for the appeal Sri Shashi Shekhar Tiwari.
Earlier Lordship on 24/11/2022. Lordship 24/11/2022. Lordship formulated a question Matter relates to a functioning of two teachers against one sanction. First lordship or second lordship or 26 lordship. That is dated 24/11.
Where is the affidavit of the authorities?
Lordship, my friend has filed the same lordship. That my friend has filed.
on 20th of December.
Since before the Honorable Single Judge Sri Dinesh Kumar Prasad not made me party.
Where is affidavit, sir?
The court. On portal it is showing lordship. Counter of my friend and reply of mine both are showing on portal.
Is it counter affidavit? Mister?
My lords.
What is the order? Earlier order? This court has asked for filing personal affidavit. Why he has filed counter affidavit? Why have you suggested your officer to file counter affidavit instead of personal affidavit?
My lords, it is sworn by the additional chief
Where
secretary.
is the personal affidavit? We are asking personal affidavit. Do you know personal affidavit means? Is there any difference between counter affidavit and personal affidavit or not? Then why you have suggested your officer? You don't read the order?
Perhaps the heading has got wrong, but
Sir, this has been examined by 2 or 3 officers, including you.
my lords.
Why you did not suggest? Before filing, you don't read. Yes, take note. Neither Deepak Kumar Singh nor Land Council, Mr. So and so. What is your name?
Priyadarshi Matri Sharan, my lord.
So and so have failed to comply the order dated 24/11/2022. To stop. Land Council has not apprised the concerned officer Deepak Kumar Singh that his personal affidavit was required to be filed. In other words, without application of mind, counter affidavit or affidavit without application of mind, the cases are being handled by the land councils for the state. When this court has specifically directed for filing personal affidavit of the concerned officer, he has no business to file counter affidavit instead of his personal affidavit.
It has personally been sworn by Deepak Kumar Singh himself, my lords.
Sir, see the title, sir.
Title.
That means you people don't read. The same is deprecated. Copy of this order shall be given to the sent to the Chief Secretary to give proper instructions to the respective officials, and so also to the respective land councils who are representing state council. This is not the first time this court has come across on more than 2 occasions when a specific direction is given to file their personal affidavit. On the other hand, they are filing a reply/counter affidavit without examining what are the directions given by the court. What is that?
No, sure. By way of when the Benjit Kumar Prasad, who was having lesser number lordship before the Honorable Single Judge Lordship, he did not make me party to the proceeding lordship, although he was knowing well.
The counter affidavit says
Lordship, they are entirely stating what they have earlier filed their affidavit lordship before the civil review proceeding lordship. Earlier they filed lordship. Earlier filed affidavit as annexed by way of reply lordship.
now judicial order is in your favor and so also the other person.
Lordship. In one proceeding, they are getting favorable decision. In another proceeding, I am getting favorable lordship. They have saying in their affidavit lordship, they have annexed one lordship. That is an inquiry report. That inquiry report is straightway in my favor, lordship.
So you have also not implicated that person as party.
No, I have implicated lordship.
Whenever
I met
in the civil review petition, his name is not there.
Civil review petition, me filed lordship after taking leave. He was certainly he was party to the proceeding because he is.
No, who has filed a CWJ?
It was lordship. It was filed by the Benjit Kumar Prasad lordship, and he did not implicate me party to the proceeding lordship. He had taken the ex parte order with regard to his payment lordship, knowingly well that I am the contesting respondent lordship. That's why while taking leave of the Supreme Court, I filed civil leave application. In civil leave application, the state authority are accepting that.
No, Benjit Kumar Prasad
is my opponent lordship.
Correct. His writ application was allowed on what date?
That is next 16 lordship.
Date I am asking you. You are saying annexure.
I am just.
It was allowed on 12/8/2010, my lord.
12/8/2010. What happened in the review?
Review decided against me, lordship.
In his favor only.
Lordship, in his favor, lordship, and in review proceeding, lordship, authority has filed that my entitlement was bona fide, genuine, and correct, lordship. That's why before the review proceeding, honorable my friend, all the officials supported my contention on the basis of the inquiry report. He was saying that Lalan Prasad was having 12 marks more than the Benjit Kumar Prasad lordship. But in place of correcting themselves, they allowed to state Benjit Kumar Prasad to continue in a different school, and they continue in a different school. From May 2021, lordship, without any proceeding, without any show cause, I have been ousted from the service, lordship, and that proceeding is pending before the District Appellate Authority, lordship. They are accepting on the one hand.
This court, division bench also affirmed the single judge order?
Lordship. That's why.
Then you have to take up the matter to Supreme Court.
Against that, I specifically pleaded by way of playing throne, lordship. One opportunity make and we ignore, lordship. The person who was contesting the case of Mukhia.
Sir, you have a remedy before the Supreme Court. You are party to the earlier proceedings in review petition.
It was me who petition, lordship.
Then you have a remedy before Supreme Court.
But by way of filing, lordship, I specific.
Where is the division bench order?
If lordship might permit me to place the.
Where is the division bench order?
That is Annexure 17. Mayor. My case, lordship, could not be ever.
Sir, counsel, when the court is asking.
Lordship, sir, I'm sorry. It is Annexure 13, Lordship, page 118, Lordship.
Page
118. Running page
118.
Lordship. Journal page 96.
Oh, this is single judge order.
Lordship. LPA is 1621, Lordship. Virtually, when against civil legal Lordship, against civil levy order, present LPA is before Lordship.
Huh?
Against civil levy application.
No, where is the question of listing LPA before single judge?
No, we are against the civil review order, Lordship. I am presenting the present LPA, Lordship. It is before you.
No, whatever it may be, sir. LPA is required to be decided by 2 judges or a single judge?
Page 96.
No, against civil review order, Lordship. And
sir, LPA number 1621.
That has been decided by division bench.
Where is the other judge name in the order?
Sorry, Lordship, it seems that
you have produced the wrong pages.
Wrong page is there.
See, petition.
Lordship.
Will dismiss, sir.
Sorry, Lordship. In view of last order, Lordship.
Huh?
In view of last order, there was direction for payment of.
No, last direction was to ascertain who is entitled.
Lordship.
Correct. Now you have lost your right. You have a remedy before Supreme Court.
Sorry, Lordship. With regard to Sally, Lordship, if Lordship.
I am fed up with you. Why you have not produced the relevant LPA order?
It seems by.
First page is LPA, second page is single judge order. What is this?
Sorry, it seems that due to mistake of her by her.
What mistake?
In their.
We'll take up this matter after few cases. You produce the LPA order. Nonsense.
After this.
After few cases, you get ready. LPA judgment.
Okay.
Upon that, you are not correcting. We have to dig and everything and search. Which is the LPA order? Which is the single judge order? This is how you are giving assistance to the court.
Number 14, Manju Devi versus the State of Bihar, others for the appeal Street Naval Krishna.
My lord, lastly, the query of the court is state that whether any departmental proceeding instituted against the father of the applicant or any suspension order has been passed against this the father of the applicant or not.
Who is appearing for respondent? Have they filed any counter affidavit? A supplementary counter affidavit system?
My lord, I had got a copy of counter affidavit, my lord, but the same is very formal. They has not stated that whether any.
Whether it is a farmer or a casual, it is irrelevant. Have they filed or not?
My lord, they had filed. I had got the copy. It is not there, my lord, but they had served me day before, my lord.
You are the state council in the present matter. Where were you? In this paragraph, you have stated that deceased employee services were terminated, so you are subjected to inquiry and other things. You have not read the paper. Due to cold, you can't read the papers. Petitioner is a widow. She is before this court. You don't want to resolve her case either this way or that way. Stating what? Guide on. What material you have produced, petitioner counsel, the appellant counsel, that your father was engaged by so and so?
My lord, petition, my lord.
Application.
Some departmental communication.
Where is that communication?
My lord, connecting read petition, my lord. Annexer 2-3.
2-3 are representation.
My lord.
Representation is not the document.
My lord. My lord, the employee was my father, my lord.
Correct, sir. What any piece of evidence? They are saying that you are not at all employed.
My lord, then I want to press second page of the order which I am challenging, my lord.
Sir, counsel, is there any material to show that your father services were engaged by so and so school? According to you, he was appointed in the year 1962. They say that it is a committee school. Up to 92 he has worked, if I am correct. There must be a piece of evidence.
So, my lord, they are submitting that after 9.
Forget about them. You apprise this court with reference to a piece of evidence that petitioner's father services were engaged by so and so.
My lord, there are some government officials' letters, my lord, from which.
Sorry, 24. 9th of May 2017. But he gave it from 1962 primary school, Sydney. And he went on absence on July 1970. Sorry, of it.
Ravi Prakash, Director, Primary Education, Government of Bihar is hereby directed to appear in person for the reasons that we find prima facie statement made para 7 is contrary to Annexure 12. He has to appraise this court as to how you would overcome the 12 insofar as master and servant relationship during the period from the year 1962 to 19
July 1970.
July 1920. With the complete records relating to the case in hand.
The record is the difficulty.
Huh?
The record is the difficulty. He couldn't.
But Annexure 12 is there, no? Have you seen it? Your affidavit is contrary to Annexure 12. In the Annexure 12, you have admitted during during the period from 1962 to 1970, he has worked.
But from 86 to 93, my lord, sir, even the salary register doesn't show his name.
His name is reflected in the salary slip.
No, not reflected, my lord.
That is immaterial. Question is, between 62 to 1970, he has worked. Thereafter, it seems he has disappeared. What action you have taken? Have you initiated inquiry for remaining unauthorized absent? Have you passed a final order of termination, dismissal, removal from service, or compulsory retirement? What action you have taken?
I'll apprise him.
Upon that, you are saying that he has not worked. How can it be? This is not fair.
After 2 weeks.
Serial number 15 is adjourned for Monday. Serial number 16, Ranju Kumari versus the State of Bihar for the Appellant Street Bar, Bhushan Chaudhary.
Appellant is Ranju Devi or Ranju Kumari?
Ranju Devi.
In the writ petition, it has been shown as Ranju Kumari.
Typing mistake, I have not detected.
Huh?
Typing mistake.
Typing mistake. Have you get it corrected from the learned single judge order?
Writ petition, it is.
ऐसा ही चलता रहता है.
Writ petition, it is correct.
Huh?
In the writ petition,
it is corrected.
Correct. It is correct.
No, sir. In the order, in the writ petition, it is shown as Ranju Kumari. In LPA, Ranju Devi. Which is correct?
Ranju Kumari is correct.
Ranju Kumari. Then have you carried out correction in the LPA?
Kindly permit me to. It has not been correct. In the impugn order also, it is Ranju Kumari.
I correction.
Ask him to do it here itself.
In the course of day.
Correct.
The LPA papers, inadvertently, name of the appellant has been shown as Ranju Devi at some of the pages. Therefore, the appellant is hereby directed to rectify the same by incorporating apparent name as Ranju Kumari during the course of the day. What is on merit?
Only in this first page it is incorrect. First and second page.
Wherever
it is LPA,
there,
yes.
Carry out.
Okay.
On merit.
Your Honor. The petitioner was working as Anganwadi Sevika.
From what date?
That date, some dates are relevant. On 8, when application was filed on 15/1/2007, selection process was started. Application was filed on 15/1/2007. 15/1.
2007.
And selection committee, there was a committee for appointment and selection. General meeting was held on 7/3/2007 and she was selected as Anganwadi Sevika.
Sir, all right, sir. What is the date of her appointment?
It is not appointment, it is selection, Your Lordship.
Huh?
It is selection. It is not a
Selection only, no
selection,
appointment.
no appointment. It is. There is no statute, rather there is some guidelines for Sevika. It is only selection. And
When she started working,
yes, that I'm giving. And the petitioner deputed for training on 8/5/2007. Selection was made on 7/3/2007. Training was started on 8/5/7. Joined the training on 13/5/2007. And thereafter she began to serve. And during the course of service, she also attended the training of job course on 11/3/2000.
Without the knowledge of the superior officers, you have shifted the Anganwadi center from one place to another place?
That is the only allegation, but it is neither in accordance with law nor it is ground for delisting, because it is not a ground for deselecting. I was selected, and subsequently on this ground, which my lords have just said, that there is no specific place for center. It is the area that is to be defined. ICDC area, पोषक area. जो गरीब बच्चे हैं उनको पोषण के.
Correct. Who are you to decide? You should have approached the higher authority.
It is in that area. Center was
whatever it may be, sir.
Kindly permit me to explain. I'm just explaining. Kindly bear with me. The area is there. In that area, there is a school. Normally, this Anganwadi Sevika used to serve meal in school. But in school premises, there was no space provided to her. That's why she, in the same area, has started in the temple where a space was given, attached to that temple. This is the only allegation. But it does not come.
It's a serious allegation.
Not
this is the only allegation.
This does not come under the provisions of irregularity. The charge is that it is irregularity. What is irregularity? That is not defined. And it is government has not pointed out that this will be the place. The government has defined the area only within that center should run.
So the Anganwadi Sevika is required to determine which place.
Yes, that from later it is stated that she was directed to hire a house. And she has, I am placing those.
Where is that direction to hire house?
Yes, I am just placing that order. This letter of the government. It is from the writ petition itself, Your Lordship. In writ petition, Your Lordship will find Annexure 1 at page number 19 of the writ application. I may be permitted to place it. उपरोक्त विषय is dated 19/12/2011. उपरोक्त विषय के संबंध में दिनांक 15/12/11 को जिला स्तरीय जांच समिति द्वारा औचक निरीक्षण किया गया। निरीक्षण के क्रम में पाया गया कि यह केंद्र मंदिर के प्रांगण में चल रहा है। मंदिर के प्रांगण में चलने के कारण कोई भी पंजी नहीं रखती।
She has acted in terms of this. Where is the irregularity? Temple to different check.
There was a direction here.
In terms of this, there is no identified place. In terms of this,
no identified place. They are just written that you are directed to start running this place from a house on rent or in a government building, and keep all the material at that place. So this is
yes.
No share.
No, she has arranged this one.
When we were asked to shift that place to some place on rent or in government,
Yes. My reply is that
from there.
my reply is Annexure 3 at page number 21.
2012 July 12.
It is specifically mentioned in Para 2, page number 21, Annexure 3. श्रीमान से प्रार्थना पूर्वक कहना है कि
The council, June 2012 to November 2012, the center was operating from which place?
In the temple itself, because where the center was.
No, who had asked you to commence the operate the center from the temple?
Once I was deputed as a center in charge, it is my duty to start wherever place may be. I could not hire. I searched. School premises was not made available. Mandir place was made available.
Was it a new center?
Yes, it is first started.
Started
first. I was searching that. Officers also directed ki please search. I replied that I am in search of the place, but I did not find. Kindly provide me. This is Annexure 321. I made a request, Your Lordship.
No, it is in the village.
It is a village area.
What is the name of the village?
It is suburban area, outer part of the Sekpura. It is within notified area committee.
She was directed to replace the center. She didn't replace, and thereafter she was given.
Whether before issuance of show cause notice, the center was operating.
Center
For that place. Yeah. That means she has disobeyed. What?
The explanation is that death of her father occurred. Thereafter, her father-in-law died, and
Within 1 month they are given notice. She made everything right. And she has assigned the reason why she should be thrown. From 2007 she is working.
She was first written to remove the place on 19th of December 2011.
Between 2000 it was anyway, notice is only 2011.
Right, the notice submitted expense on 17th of January. After a removal notice, tried it on 20th of January.
No, we don't know. Provision for imposing fine, something. There is on the scoreboard there is no misappropriation. No, but the removal is not based on that. That she has disobeyed the order. No?
Issue. There is no light at the center. No drinking water, toilet. Only 5 child was in uniform. No storage. 60% of this.
No, this was the proposal in the notice.
Yes, sir.
Is it notice or final order?
Final order.
In the notice,
Yes, yes, sir.
then ask the state council on this point.
When you pass the removal order of this Anganwadi worker, you have written a number of irregularities, for which you have not sought any explanation from her. It came in the removal order for the first time. How could it be? If she was to be removed on the basis of these grounds of
irregularity,
so you should have asked for
is not present in notified area. It is stated in LPA by petition lordship. Anganwadi center was not being and running and notified place lordship. Second is irregularity lordship. He is not present.
Yes, irregularity
When is
to her. Irregularities were not put to her.
additional collector when inspector and dated 15/12/2011. It is
Showcase note.
annexure para number 8 in my counter affidavit, Lordship.
Madam, in the showcase notice, have you indicated these are the irregularities?
No. There is nothing. Second.
Only stated in the showcase notice, has shifted Anganwadi center from temple to so and place. That's all.
And
the other material stated for termination or removal are all extraneous material which is behind the back of the petitioner.
Yet another one point is also for your Lordship information that the officer who has passed the order is not competent. District officer is competent, and this is a program officer. It is another point. An opportunity has not been given. 3 points I have raised in the writ petition also.
ये कहाँ पर है कि वो डिस्ट्रिक्ट ऑपरेट करेंगे, डिस्ट्रिक्ट प्रोग्राम नहीं करेंगे?
2006 का जो प्रोसेस है, जो इसकी गाइडलाइंस है, उसमें है रिट पिटिशन में हमने लिखा है, स्पेसिफिक लिखा है. आई हैव मेंशन्ड दैट द कंप्लायंस हैज नॉट बीन डन एंड द ऑर्डर वाज पास्ड बाय एन ऑफिसर हु इज नॉट कॉम्पिटेंट. पुराना जो मार्गदर्शिका बाद में चेंज होकर 11 में 12 में लागू हुआ, पहले नहीं था. पहले डिस्ट्रिक्ट ऑफिसर को था, ये जिला पदाधिकारी. रूल 10 था, उपरोक्त खंड का 8 एवं 9 के संदर्भ में सेविका सहायिका को चयन मुक्त करने संबंधी प्राप्त प्रस्ताव पर जिला पदाधिकारी समीक्षोपरांत जिला पदाधिकारी डिस्ट्रिक्ट ऑफिसर का एंटर आफ्टर अमेंडमेंट. तो द सिलेक्शन वाज अंडर द ओल्ड रूल्स.
With the administrative order, reasons must be present after giving the third person.
This LPA is allowed.
Now the case fixed a few cases, serial number 9, the state of Bihar, Surya Singh Sahu for the prisoners, Shri Sanjay Kumar Kosarve.
Yeah, please, Your Honor. Not the serial application, my lord, for question, my lord, CAT order, my lord, dated 30/1/2019, 30/1/2019, my lord, hereby the learned Central Administrative Tribunal Patna bench, my lord, has quashed the my lord departmental proceeding initiated against the my lord applicant, respondent number 1, my lord, under Rule 8(2) of All India Services in Rule 1969. And further, my lord, was the letter dated 28/8/2018 issued by the Joint Secretary Department of Home Government of Bihar, Patna. The defense statement of the my lord respondent number 1 has been my lord rejected. My lord. The honorable lord, the fact of the case is, my lord, that the my lord On 29/9/2013, my lord, the respondent number 1 was posted, my lord, as the first commandant cum principal and MPTC, my lord, Dumrao, my lord.
Huh?
Lord, on 29/9/2013, my lord, the respondent number 1 was posted as commandant cum principal MPTC Dumrao, my lord.
29/9/2013.
9/2013, my lord.
13.
13.
Posted as commandant?
As the first commandant cum principal.
Lord, it is
MPTC.
29/3, my lord.
29.
29/3/2013 by notification 2486.
All right.
I was posted there.
First commandant, come principal.
First commandant.
Lord, MPTC.
Huh?
Cum principal, Lord.
Come principal. Huh?
MPTC. Military Police Training College. MPTC. Military Police Training College. Dumrao.
And
which place?
It is Dumrao, my lord. It is about 130 kilometers away from Patna, my lord.
the district of Bakshan. Lord, my lord, there, my lord, she remained, my lord. She remained there, my lord, 2014 to 15, my lord.
What is meant by 2014 and 15?
Lord,
There is no exact date.
Lord, I am giving the date, my lord.
September 2014.
8/4/2013. 8/4/2013 to 9/9/2014.
She was there.
She was there, my lord. Lord, during her stay there, my lord, she had purchased, my lord, many articles, my lord, for officiating, my lord. And my lord, after her transfer, my lord, the audit was made, my lord, and it was found, my lord, that there is, my lord, financial irregularity, my lord, in purchasing of the, my lord, the articles, my lord. And my lord, after inquiry, my lord, charge memo was framed, my lord, in which, my lord, the charge was against her, my lord, that she.
What is the date of filing charge?
Lord, date of filing of the charge is, my lord,
10/5/2018.
8/5/2018, my lord.
Why such a long?
Lord,
4 years.
Lord,
more than 5. Almost 4 years.
Almost 4 years, my lord.
Why?
Lord, the inquiry was made, my lord. First inquiry, second inquiry, my lord, and lastly, my lord, 3-man committee inquiry was made, my lord, and report was submitted, my lord. And it was found that there is, my lord, financial irregularity, my lord, done by the, my lord, respondent number 1, my lord. Lord, the charges were, my lord, that she had not maintained the register related to accounts, my lord.
We are not on merits. Because she has challenged the initiation of inquiry. Now you have to stick to the issue whether the tribunal is empowered to interfere with the charge memo or not. That's all.
Lord. Lord, the learned tribunal, my lord, has, Lord, based upon the, my lord, judgment, my lord, in which, Lord, that is 1994, Volume 3, Supreme Court Cases, my lord, 357. Union of India and others versus Upender Singh.
The judgment is not relevant.
Lord, judgment is, Lord, of twofold, Lord. Lord, the criteria, Lord, in which, Lord, it is said that there is, if there is apparent, Lord, that the charges are not, Lord, applicable, Lord, then only, Lord, the
applicable.
charges, my lord, if it apparently, my lord, appears, my lord, that the charges are not proved, charges, my lord, that is not.
That is not the principle. The principle is whether the initiation of inquiry is by incompetent authority or not.
No.
Have you brought Kuni Shetty versus Union of India?
Lord.
Where is that judgment?
Lord, that judgment is with me.
And thereafter, Prabhat Kumar.
Thereafter, Lord, I am relying upon the judgment, Lord. This is, Lord, 2021, Volume 2. $612.
You are not given.
Lord, list was perhaps.
No, without that, how can you argue? Pass on your book. Which paragraph you want to rely?
Quoted. There is limited jurisdiction, my lord, under Article 226, my lord.
Sir, which paragraph, sir?
Paragraph, I am not noted.
Ask him to mark the paragraph and give.
I am sorry.
What is that? I am hearing sorry for the entire day. Sorry.
Yes.
22-23, my lord. 22-23.
This is not relevant. We are in the present case. Issue is whether charge memo could be interfered by the courts or not. What you are citing is it is a matter relating to completion of inquiry. What is the scope of judicial review?
Lord, that is the scope of the judicial review.
Sir, scope of judicial review after completion of inquiry. We have not yet reached that stage in the present case.
Lord, the initiation of the proceeding, my lord, has been quashed, my lord. That the
Sir, in the cited decision, is it relating to initiation of inquiry?
Not
It is not. It is a final order.
not. Lord, 94, 3 para 6, my lord. Please, my lord.
Sir, thereafter, two judgments are there, according to me. Kuni Shetty versus Union of India, Prabhat Kumar versus Union of India. Where are those judgments?
Those judgment, my lord, are not.
This is how you people research on the subject.
my lord, since my lord, Mr. P.K. Verma was.
All right, please take your seat. We'll take care of your case.
I will bring Lord.
Fifth, respondent counsel.
Lordship.
How do you overcome Kuni versus Union of India and Prabhat Kumar?
Lord, if the facts of the case is looked into from a very narrow prism, my lord, whether the charges which emanates, my lord, from the service of the charge, my lord, that I had, my lord, violated the Bihar financial rules in the.
Sir, we are not concerned with that.
I'm just giving a background, both bit of background reference, my lord, fact are very necessary, my lord, to adjudicate this thing. I know, my lord, I'm down the, my lord, uphill, it is an uphill task, my lord, in a judicial review at the initial stage, at the nascent stage of a departmental proceeding, the interference by this honorable court. But there are,
therefore don't say anything about on merits. We are concerned with the whether court can interfere with the show or not. Is there any judgment overlooking or overriding Prabhat Kumar judgment or not?
My submission is, my lord, with regard to the just now the
that is not relevant.
That is the final order, my lord. But it says, my lord, even at the stage of departmental initiation of departmental proceeding, if on the basis of perusal of the charges, after looking into the background, no offence is made out, then it can be quashed at the nascent stage.
That cannot be examined by the courts.
One thing, my lord, kindly bear with me, my lord. One thing is there, my lord, until and unless a member of the All India Services, my lord, conducts a does a misconduct, my lord, no departmental proceeding can be initiated, my lord. Now the facts which I have brought on the record, my lord, on behalf of respondent number 12, to this effect, my lord, she was transferred to MPTC, which had no land, no office.
Sir, we are not on merits. We are not on merits. This court cannot examine.
At least, my lord, a palpable reference to the background is necessary, my lord, to appreciate her, my lord, defense before this honorable court. And this is what precisely the CAT has done, the Central Administrative Tribunal has done, my lord. And, my lord, Central Administrative Tribunal was not exercising the jurisdiction under Article 226, my lord. It was looking into the matter overall, my lord, the overall things, my lord.
Yes, sir.
So, my lord, a person who has been transferred to a place where there is absolutely no land, no office,
Tribunal Act,
and then it says, my lord, the charge says, my lord, you had not taken the permission of your senior authorities. This is absolutely a non-honest charge, my lord. On the basis of the documents which I have brought on the record, my lord, which in, my lord, volumes speaks about this, my lord, that she has exercised everything with due.
Sir, we are not on merits.
And it cannot
address the argument on merits of the case.
Your Lordship, a bit of merit is necessary, my lord, to appreciate at least what are the point of law involved, my lord. So, my lord, if I am able to show and demonstrate before your Lordship, my lord, as it was demonstrated before the Central Administrative Tribunal, my lord, that one was transferred to a place, my lord, where she was having nothing, my lord, no staff. And you cannot say your staff didn't maintain the records, and allegation was you didn't maintain the record. In fact, my lord, after 11 months and after 15 months, my lord, the first staff on endeavors, my lord, and the DGP training, my lord, he had been issuing giving me direction, my lord, you have to raise a battalion from the scratch. So I have to, on the one hand, I was caught under the devil in the deep sea, my lord. On one hand, I was there to, my lord, obey the orders of my senior officers, my lord, who the DGP training had asked me to raise the battalion, and which was to be raised from the scratch, my lord. Now, on that account of the matter, my lord, this, thereafter, a direction was, my lord, taken, my lord, from the DGP headquarters, my lord, who and training, my lord. And they allowed me to take a rented house, my lord, at Dumrao, my lord, and to officiate my official works, my lord, right from that was given later on, my lord. After much endeavorance, my lord, for 11 months, my lord, she was deprived of even salary, my lord. So it was in a common parlance said to be a shunting post, my lord. But I'm putting a question to myself. If a commission, one-man commission is formed, my lord, and no infrastructure is provided, my lord, how can that one-man commission can work at all, my lord, if the stenos are not there, if the Staffs are not there, my lord.
We are not the persons to decide all those.
My lord, this is necessary, my lord, at least, my lord, to appreciate that absolutely no offense is made out, because two things are there, my lord. When the notices was given to me, my lord, you will have to face the departmental proceeding, they have deliberately omitted, my lord, to take into account, my lord, two very, very, very important aspects of the matter. One was the inquiry made by the DIG training, Vikash Vaibhav, which I have annexed, my lord, in my counter affidavit, my lord.
We are repeating. Please.
हुजूर, इतना तो सुना जाएगा ना.
Can't decide.
इतना तो सुना. I know, my lord, the limitations of this honorable court, and simultaneously, kindly have appreciate, my lord, my predicament. I cannot demonstrate without adverting to the facts, my lord, that these offences which have been framed, my lord, against me, those charges are absolutely not made out. And, my lord, the initial thing, my lord, after 2.5 years of the order of the Central Administrative Tribunal, my lord, this writ application was filed before this honorable court. And there is absolutely no explanation whatsoever why this delay had occurred after 2.5 years, my lord.
We'll consider that.
My lord, after 2.5 years. Now, my lord, what I say, my lord, if the lordship, my lord, look into the charges, my lord, no offense is made out of the misconduct, my lord. And, my lord, I am fortified in my submission with regard to the decision, my lord. I have given the list of cases, my lord, to the learned court master, my lord. 1979 Supreme Court, my lord, is a very celebrated case, my lord, with regard to misconduct, my lord. My lord, it may be that I had made some, my lord, mistakes, my lord, but those were, my lord, it cannot be said that I had conducted myself anything.
Can this court decide all those matters?
My lord,
whether you have committed misconduct.
The courts are here.
What is the what amounts
are here to impart?
What amounts to misconduct?
The courts are here also to impart justice, my lord, not to look into the hyper-technical things, my lord, in order to, my lord, appreciate.
They are bound by Supreme Court decision. Lord, please apprise any latest decision overcoming the Prabhat Kumar decision.
That is itself, my lord, the thing, my lord, at the stage of framing of the charge also, the High Court, this honorable court, in the judicial review can interfere if it finds that absolutely no offence is made out.
Only
and it is based on a non-est charges, my lord. The non-est, I say, my lord, non-est, why I say the non-est, my lord, if your lordship, I have filed a very detailed counter affidavit before your lordship. I know meticulously your lordship goes into the entire facts and circumstances of the case, my lord. Now, lord, there are a number of documents which they have not controverted in their rejoinder. Lord, it is not that they say it is an incorrect letter. This letter is a one-sided letter. It was not given to them. Every stage, Lord, I had obtained the permission of my superior officer.
And apprise the inquiring officer.
Lord, I know that this objection will fall from your lordship, my lord. I know. But, my lord, simultaneously, why at all? My lord, initiation of a departmental proceeding is not a very trifling matter, my lord. It is a serious matter, especially for officers. I don't say, my lord, but especially for.
Oh, they are claiming
a lady officer.
They are claiming privilege that they.
No privilege, my lord. No privilege at all, my lord. I am just saying, my lord, kindly look into will this honorable court, my lord, look the other way, my lord. If I am able to show to your lordship, my lord, in the place where I was transferred, there was no office. The place where I was transferred had no allocation of fund. And after 11 months, I started getting the salary. My lord, in the meantime, the DGP training, my lord, had directed me to raise a battalion from the scratch. Now, I had to raise it from the scratch, my lord. That means I needed an office to at least officiate, my lord. And all those things, my lord, two things. The non-est thing is, my lord, this, my lord.
We are not here to on merit, sir.
But two things has to be taken into consideration.
Consider.
Number one, the report of my lord Vikash Vaibhav, DIG training, my lord, at that point of time. He has categorically gone on the record by saying, I'll humbly beseech your lordship, my lord, to kindly see my lord, that annexure in my counter affidavit, my lord.
You get that?
Yes, my lord. Kindly, my lord, bear with me, my lord. I know, my lord, I have a very uphill task, my lord, to perform, my lord, but kindly bear with me to at least inculcate and persuade your lordship to come to this irresistible conclusion. No offense is made out. Now kindly come to this.
That cannot be examined by this court.
My lord, it can be examined, my lord. Lord, if the court, my lord,
We are not going to examine.
matter with open eyes, my lord, it can be looked
We
into.
are not going to really appreciate.
अच्छा थोड़ा सा चीज तो देखा जाएगा थोड़ा सा आप kindly have a look to annexure 24 at page 94, my lord. Kindly, my lord. This is a report of Vikas Vaibhav, and why this report came, my lord? My lord, the three-man committee on the basis of which they are proceeding against me, my lord, they had at no point of time issued notice to me. My lord, everything is against me, my lord. But I was not made even aware of the things, my lord, what the three-man committee is coming to the conclusion. Never at any point of time. When I was, my lord, this serving as a DIG, this SP, my lord, SP of weaker section CID, my lord, I got a notice. The three-man committee has indicated you give me a show cause. Now, I was caught unaware, my lord. Have lordship got it, my lord? This is annexure, kitna?
Sir, we already expressed. We are not going to.
Huzur.
On merit.
94 was.
It is an initial stage. Go and apprise the departmental inquiring authority.
I knew, my lord, this, my lord, I know, my lord, very, my lord, meticulously dwells into the entire facts of the case, my lord. It is not that my lord will shirk from that, my lord. Huzur, 2001 ka 2 SCC, I have given the list, my lord. 2001 2 SCC, page 330, my lord, paragraph 33. I just read out to your lordship, my lord. Kindly bear with me, my lord. Dice is heavily loaded against me, I know, my lord. But still, my lord, I am making the endeavors, my lord, to persuade and inculcate upon your lordship, my lord, to kindly look into the defense of the respondent, my lord, which has been looked into by the Central Administrative Tribunal. My lord, paragraph 33. While it is true that justifiability of charges at the stage of initiation of a departmental proceeding cannot possibly be delved into by any court pending inquiry, but it is equally well settled that in the event there is an element of malice or malafide, motive involved in the matter of issue of a charge sheet or the authority concerned is so biased that the inquiry would be a mere farcical show and the conclusions are well known, then and in that event, law courts are otherwise justified in interfering at the earliest stage so as to avoid the harassment and humiliation of a public official. She is being thoroughly, my lord, subjected to harassment and humiliation, which is quite evident, my lord, from the report of this Vikas Vaibhav, my lord, which I am trying to, my lord, persuade your lordship, my lord, to kindly come to this, my lord. What is the, my lord, the operative portion of this? He had looked into the entire matters. When I gave the show cause, my lord, pursuant to the three-man committee's show cause to me, when I gave a detailed show cause, they were, my lord, they were fixed, my lord.
What should we go and say all these things for the inquiring authority?
They are prejudging the matter. I cannot get a relief and I cannot get a justice, my lord, from them, my lord.
You have a remedy elsewhere.
My lord,
Prabhat Kumar, latest.
Lord, the other decision is, my lord, 2012, 11 SCC, page 565, Secretary Finance, my lord, against Prakash Chandra Mirdha. Lord, in which paragraph 8, my lord, I will read out to your lordship's kind convenience. The law does not permit quashing of the charge sheet in a routine manner. In case the delinquent employee has any grievance in respect of the charge sheet, he must raise the issue by filing a representation and wait for the decision of the disciplinary authority. In case of the charge sheet is challenged before the court or tribunal on the ground of delay in initiation of the disciplinary proceeding or delay in concluding the proceeding, the court may quash the charge sheet after considering the gravity of charge and all relevant factors involved in the case, weighing all the... This is paragraph 8, my lord. Paragraph 8, my lord. And my lord will kindly appreciate one aspect of the matter, my lord. My lord, now the delay is of more than 4 and 6 years, my lord. And it is a witch hunting, my lord. Nothing more, my lord. It is a witch hunting, my lord. And this honorable court will, my lord, at least.
All right, that's all.
नहीं अभी हुजूर जरा सा kindly bear with me, my lord. Kindly bear with me, my lord. My lord, annexure 24 at page 94. My lord, kindly see, my lord. And this is the operative portion. The purchases made were not regular and fully in sync with financial rules. Her position needs to be considered in the light of peculiar and difficult circumstances under which she was posted as in charge of the unit, which was yet to be raised. Opined, अब देखिए इनका finding क्या है? Opined that many facets found irregular was committed in the overall bona fide interest of raising unit from a scratch. No proper and regular office was there, as regular accountant was not there, DSP to assist. All needs to be viewed sympathetically in the light of correspondences made by the respondent for their posting and deputation. Now, my lord, when they had given a show cause to me, and thereafter, my lord, all these things have come on record, my lord. They are not even referring to this, and they, my lord, by the orders of the Honorable the Chief Minister, my lord, the matter was also referred to the vigilance. And vigilance came to a categoric finding, my lord, which is there.
Can we appreciate all these things at the stage of issuance of second show cause notice?
Pardon, my lord? I
appreciate all these things. Can we appreciate all these things at the initial stage when the show cause notice was
Lord, at the initial stage, the delay, my lord, at least prompt your lordship.
Sorry, Mr.
To these matters, my lord.
Sorry, we will not.
After 2.5 years, my lord, this application was filed, my lord. Absolutely no explanation to that.
Already it is submitted.
एक बात अब बोलते हैं कि you have misappropriated the items, my lord. They have said it is absolutely a non-est in view of the.
Can we decide that whether you have misappropriated or not?
My lord can decide that in view of the vigilance committee, my lord, having probed into the matter and had said the entire articles have been returned and no financial irregularity has been committed, and this was caused on certain existing peculiar circumstances which was totally beyond the control of the officer. This is the finding of these two, Vikas Vaibhav and Vigilance Inquiry. And they have not taken note of all these things, and they have initiated the departmental proceeding. And what I am trying to impress upon your lordship is, my lord, they have asked the show cause. In the show cause, I have written everything, my lord. And they ignore to look into and to give a finding, my lord, with regard to these two things, my lord. That shows their malafide and their... I am extremely sorry, my lord. That shows their malafide and their pre-mindset, my lord, to put me to this humiliation and harassment of nothing. And my lord, I was never suspended, my lord, by the department. Your lordship will take notice of this, judicial cognizance of this fact. Rather, I was promoted during this period, my lord, as DIG, and at present I am the DIG wireless.
I don't know why all those submissions.
It's just because of this thing, but to show, my lord, what are the malafide things, my lord? What are the malafide things? Because all these things, they have not. Why at all, my lord? My lord, to give a show cause, my lord, is an act of fairness, and to not give, my lord, the things, my lord, in the
petition.
In the Huzur Thoughts, my lord is.
Petitioner state has assailed the.
My lord is shutting me, my lord. I would try to, my lord.
Order dated 30th January 2019, passed in MA. /050/00384 of 2018 and 517 of 2018.
But
no, before that you mentioned OA/050/00754 of 2018. Dated 30th January 2019, passed by the Central Administrative Tribunal, Patna Bench, Patna, for short CAT. Next paragraph. The respondent is an IPS officer of 2006 batch of Bihar cadre. She was posted as a first commandant and principal of
First commandant, my lord.
first commandant principal, Military Police Training College, Dumro.
Dumrao.
On 29/3/2013, she was working as such till 9/9/2014. During the intervening period, she was not provided office facilities, including various infrastructure to run the administration of the post of first commandant cum principal, MPT College, Dumron. For want of sanction of certain monetary, a certain amount to run the aforementioned office, she was not provided financial aid by the competent authority or slash government, whereby she was compelled to utilize her personal money in order to facilitate infrastructure to the office. Please stop. That apart, there were certain allegations against her in not maintaining the office records. She was subjected to disciplinary proceedings in initiation of inquiry on 10/5/2018 under sub-rule 2 of Rule 8 of All India Services within bracket discipline and appeal bracket close rules, 1968.
69, my lord. 69.
69.
My lord.
The following charges were framed. Is on page 113. Following 5 charges have been framed. The petitioner, respondent, filed her explanation to the charge memo. And it was rejected.
Eight 18.
Where is the OA? Where is the original application?
That is not on the record.
Tune order is there only.
You have not produced the original application?
No.
In the original application, filed before the CAT, she has questioned the memorandum dated 10/5/2018 and a letter dated 28/8/2018 within bracket annexure A1 and 8 original application. the tribunal, next paragraph, the next paragraph, CAT allowed the original application filed by the respondent while quashing the initiation of inquiry. Therefore, she was compelled to utilize her personal money while purchasing various office materials, and thereafter she has claimed reimbursement. So, in the light of these facts and circumstances, the alleged charges number 1 to 5 are baseless. In fact, preliminary inquiry has been held in which the inquiring officers, preliminary inquiry authority have taken note of the deficiencies in running the office of the first commandant and the principal MPT College Dumro by the respondent. Therefore, there is no infirmity in the order of the CAT dated so and so passed in OA number. Hence, no interference is called for. Heard the learned counsels for the respective parties. The respondent of OA before the Central Administrative Tribunal is not maintainable for the reasons that Section 19 of the Administrative Tribunal Act reads as under. Explanation to subsection 1 of section 19 is crystal clear that for the purpose of subsection 1, order means an order made by the concerned authority. Initiation of inquiry dash show cause notice is not an order so as to entertain respondent's application under section 19 of the Administrative Tribunal Act 1985 by the CAT. Full stop. Next paragraph. Further, assuming that Central Administrative Tribunal has a jurisdiction to interfere with the show cause notice, the show cause notice could be interfered by the tribunal/courts only under two circumstances, namely in the initiation of inquiry/show cause notice is in violation of relevant rules or by an incompetent. Both the ingredients are not forthcoming so as to interfere with the show cause notice and consequential rejection of a respondent's explanation on the charge memo. On this issue, Apex Court, in the case of Kunni Shetty versus Union of India, and another versus Kunni Shetty Satyanarayana, reported in 2006, within bracket 2006, 12 SCC, page 28, in para 13.2. It is held as under. Further, Apex Court has reiterated the aforesaid principle in the case of Ministry of Sorry, in the case of the state of Uttar Pradesh and others versus Prabhat Kumar. No. Secretary, strike off everything. Secretary, Ministry of Defence and others versus Prabhash Chandra Mirda. Within bracket 2012, 11 SEC. Page number 565. Para 12. Reads as under. In the light of the aforesaid principle laid down by the Apex Court, the CAT has committed error in interfering with the show cause notice / initiation of inquiry dated 10/5/2018 and consequential order of rejecting the respondent's explanation on the charge memo dated so and so. Next, in the light of these facts and circumstances, the state petitioner have made out a prima facie case so as to interfere with the CAT order passed in OA number so and so. Accordingly, it is set aside. The concerned authority is hereby directed to complete the inquiry proceedings within a period of 6 months from the date of receipt of order.
Lord, I'm not in the habit of interfering, Your Lordship, Lord. The delay of 2.5 years, which Your Lordship said I'll be reflecting order.
Make note of I will insert it at appropriate place. Counsel for the respondent submitted that there is a delay of 2.5 years in filing the present writ petition against CAT order. There is no limitation so far as filing the writ petition against the order of the CAT in the light of the Apex Court decision in the case of Union of India versus Chandrakumar reported in 19.
And whether this respondent is, my Lord, entitled to one more relief, my Lord, if the things are not completed within 6 months, it has been, my Lord, this Damocles sword has been hanging over me, my Lord, for no reasons. So, my Lord, that aspect of...
No, sir, there are serious allegations in respect of charge number 2 is concerned. That she has not maintained the accounts book.
Because there was no staff with me. The day the staff, after 11 months,
all those
came to me, my Lord. I could not have maintained.
There is all this contention before the inquiring authority.
Then I bow down to your Lordship, but I was just trying to seek some relief for her, my Lord, on account if it is not concluded within 6 months. Then whether the necessary, my Lord, the consequences will...
Sir, it is a prima facie financial irregularities have been noticed in charge memo. You may say that it is not correct.
Your Lordship will go into the facts of the case. There is absolutely non-S charge. When the vigilance has said this thing in no irregularities committed, and the entire items have been given to me.
Best Empire and Berry.
And it was totally beyond the control of the officer, what has done.
Correct, sir.
If all these things are taken into consideration...
Sir, you have a good defense before the inquiring authority.
But I don't have the good disciplinary authority there who are sitting there with a mindset, my Lord. Who are sitting there with mindset. And I thought, my Lord, this honorable court will come to my rescue, my Lord, at least when I'm not being protected by my own persons, my Lord. By my own... Yes.
Such things
and
happen.
She has never been suspended, my Lord.
Things happen when you enter the service.
And they are giving they have given the promotion also, my Lord.
Good. Yes, sir.
Oblige, my Lord.
Under the heading for hearing serial number 33, Arun Kumar Sarma and others versus the state of Bihar and others for the appearance Sri Jitendra Kumar Roy.
Your Lordship, the officers are here, Your Lordship. I'm filing supplementary counter affidavit. Record the
fact. On filing supplementary after supplementary.
Lordship, it is with respect to the queries made by this court, Honorable Court, Your Lordship, on the last occasion, that whether the cadre of Dalpati is district cadre or state cadre. That has been brought on record, Your Lordship. We have annexed the relevant documents.
Where is the combined seniority list prepared?
No, Your Lordship, since it was a district cadre, so district-wise cadre has been, district-wide seniority list has been prepared.
Then if that is the case, why you have not distributed equally 531 vacancies?
Your Lordship, at the relevant time, Your Lordship, there were several panchayats where the panchayat sevaks were working. So, on the vacant post only, we had appointed. We were directed to be appointed. We have
not appointed, sir. Newly created 531 vacancy.
Your Lordship, on that they were absorbed, Your Lordships. I'm sorry, Your Lordship, that they were absorbed. There were 843 posts in undivided state of Bihar after bifurcation, Your Lordship.
Why in this district was not given
Your Lordship, already there was surplus.
No, similarly it was in the case of Patna.
No, Your Lordship. Huh? Your Lordship, I'll show you, Your Lordship.
Who is appearing for petitioner?
Your Lordship, we have informed Mr. Arun.
Appellant, LPA, appellant.
Mr. Arun Kumar is appearing, Your Lordship. He has recently filed Wakalatnama in this case. The earlier advocate is no more, Your Lordship.
Other counsel must be there, no? Last time we have asked him.
And the case on which they are relying, that pertains to Amod Kumar Singh case, Your Lordship, that pertains to the district of Gopalganj. And in our case, Your Lordship, the district is West Champaran. There was no vacancy so that these persons could have been absorbed, Your Lordship. That is why they were not absorbed.
Last year.
Who is the officer who has come here?
District Magistrate, West Champaran, and Deputy Secretary.
How you will, where is the Deputy Secretary? You are the Deputy Secretary. Where is the material to show that it is a district cadre?
The latest affidavit filed today, Your Lordship, Annexure A, page.
ये हम लोगों का सेवा शर्त नियमावली 1989 है सर, और इसमें ये कंडिका 3 में सर संवर्ग का गठन है।
We have brought up, Your Lordship, write this supplementary affidavit, Your Lordship. It has already been served to the appellant, Your Lordship.
If you are giving now?
Yes, Lord's evening he has given me a copy. Yesterday evening, Milords, he has given me a copy of supplementary counter affidavit, Milords. Although, Milords, he has enclosed 2 rules, but whatever my lords had sought for in the last occasion, Milords, that has not been properly replied.
That has not been produced?
Not properly replied, Milords, I am saying. Because, Milords,
what time or you want to address?
Because, Milords, he has given just evening, Milords, so some time may be granted so that I may go through and. नहीं कल दिए हैं सामने थे भी नहीं
पंचायत सेवा
district cadre. Now we so far as the list comes, and where is the notification identifying these many vacancies? For example, 10 vacancies, 20 vacancy, like that. So far as East Champaran.
Lords,
We are concerned with which district?
West Champaran.
Where is the notification identifying Panchayat Sevaks for the 10 or 20? Where is that notification?
There is no notification, Your Lordship, but there was a detailed chart which we have annexed, Your Lordship, where they
No,
are.
why there is no notification? Chart is for your office purpose. Where is the notification allotting these many vacancies to each of the districts?
Since there was no vacancy, Your Lordship.
All right, sir. Initially, where is the notification? Assuming that 20 posts are earmarked for this district.
Your Lordship. Your Lordship.
There are some to issue. So for example, Patna, 20 vacancy. 531 is subject. First, initially, what was the? According to them, there were no vacancies. Among the 531, few, something.
In the last affidavit.
The vacancies are district wide.
Your Lordship.
Prepared on the chart. Where is the notification?
Your Lordship, I'll just show you, Lordship. I'll just show you. It is on record. Kindly have annexed D series, Your Lordship. In the last affidavit, Your Lordship, not this, but the last affidavit, D series 1. This affidavit has been filed on.
When you identified the vacancies, you issued any notification?
Your Lordship, it was communicated to every district magistrate, Your Lordship. It was communicated, Your Lordship.
Sir, cadre notification is not required to be passed under Article 309 or 162. The Panchayat Sevak post is created under 162 or 309 of the Constitution.
162.
Huh? Yes, Deputy Secretary. The post is created under Article 309 or 166 of the Constitution.
163.
Where is that?
This is the notification.
This is executive order. Yes. Executive order. Correct. The allocation of
Allocation of when
this is
Same secretary. Different secretary agreement
under 166 of the Constitution? No, any rules?
Panchayat Raj Act. Yeah.
At serial number 19.
98. What is the cadastre number of posts allotted to this?
At serial number 19 is the district West Champaran, Your Lordship.
Additional. Prior to that, the restructuring of panchayats, number of panchayats, number of working panchayats after creation of post, which were to be filled up, additional posts.
Now, it has been identified and vacancies have been notified.
Yes.
Now, 531 vacancies are in addition to these vacancies. They have to distribute 531 vacancies among the districts. Why they have chosen other than this 19 district? Ask me.
You have submitted this letter about creation of certain posts. 531 vacancies were in addition to these posts.
No, Your Lordship.
Milord, this is the position. This is the position, Milords. My learned friend is confusing the entire matter. Milords, may kindly have a look to one of the letter issued by the Principal Secretary to the Accountant General, that is at page 24.
531 vacancies were newly created.
Milord, 531 posts were kept. Milords, my humble submission, Milords, one line.
Your State Council, why these vacancies were not distributed? These 531 vacancies were not distributed to each of the districts.
Your Lordship, at the relevant time, there were in every panchayat, there was a provision for a panchayat secretary, Your Lordship. What happened that in some of the districts, there were more than the required number of panchayats. In some of the districts, there were less than the required number of panchayats. So they were distributed as per the requirement where there were less number of panchayat secretaries, Your Lordship.
Illegalities have been.
In the district of West Champaran, there was surplus already. In the list, Your Lordship.
How many were surplus? What was the surplus number?
Your Lordship, it was around eight surplus, Your Lordship.
In that notification, is there any?
Okay. In the last column.
Where is that notification of 531 vacancies?
531 vacancies notification.
सर ये यूनाइटेड बिहार में हम लोग मैंने किए थे। हाँ, यूनाइटेड बिहार के बाद ये हम देख लेते हैं, ये हुआ है 2008 में।
In 2008, that was.
Where is that notification? Newly creation of 531 vacancies.
Right to this.
हाँ, ये दे दिया गया।
After bifurcation, you can exclude such of those districts which do not fall under Bihar. Is in the year 298.
They are talking of
11/2008.
43 vacancies.
Wide notification number 2815 dated 11/6/2008. All these 531 posts were newly created posts were.
They are keep on arguing the newly created. by virtue of judicial pronouncement, has a different decision to create 531 vacancies. This is further allocation to very
I-31 posts remain for Bihar.
created.
It was newly created at the time, 98. Probably it was not from 98.
You mean to say this 531 vacancy? But then why are you not sure?
What is the date of this notification?
It is in continuation, Your Lordship. A notification dated 2815, notification number 2815 dated 11/6/2008. It has been annexed as Annexure B to the counter affidavit filed on 12/2/2020. Unfortunately, this could not have been that notification.
In each and every litigation, same thing. It is not unfortunate.
Here we have discussed all the details. There are several cases have led to this creation of 530.
Milord, my
phrase.
531. Yes, my grievance is raised upon notification dated 11/6/2008, milords. That my friend is referring, in which that letter starts, milords, the माननीय उच्च न्यायालय पटना में लंबित अवमाननावाद 704 of 2007 अरुण कुमार शर्मा एवं this is the appellant before my lords. Milords, it has been decided that all these 531 posts will be kept reserved for only compliance of the different orders which had got finality by this honorable court, milords. My claim is that my order passed in our favor has got finality by the honorable apex court also, milord, in case of Amod Kumar Singh in year 2005 itself. When the order was not complied, I filed contempt application. During contempt application, milords, government has taken decision. Even this aspect was raised before division bench that has also been brought on record in the counter affidavit Subhash Chandra Shukla case, milords, in which paragraph 15 and 16, the division bench of this honorable court has specifically said that yes, only in compliance to honorable court's order, those posts will be filled up. That will be filled up by earlier process from the Dalpati. And thereafter, when that post will be exhausted, thereafter fresh appointment will be done in view of the latest rules, milords. So my claim is, milords,
No, 531 vacancies were specifically fill up Dalapatis.
Deputy Secretary, these 531 vacancies which were created in 2008, that is earmarked for only to Dalpatis?
सर अगर अलाउ हो तो हम सर ये अनाउंस करें सर, ये सिर्फ पंचायत सेवक की जो है मैंने ये पोस्ट क्रिएट हुआ सर.
Sir, have you understood the court question?
Sir.
531 vacancies which were newly created or not?
No sir.
It is not newly created.
क्रिएटेड नहीं हुआ था सर, जो पूर्व में सृजित पद से सर.
Then before the Supreme Court or this court, you have given the admission that we are going to create a certain post to accommodate Dalpatis.
Sir,
which are those posts?
सर हम लोग जो सृजित पद था सर उसमें से 531 पदों पर केवल दलपतियों की नियुक्ति का सर हम लोग ये आदेश निकालें सर, माननीय उच्च न्यायालय के आदेश से.
यही है हुजूर केस हमारा. अगर ये 531 पद को डिफरेंट ऑर्डर के कंप्लायंस में भर दिए हैं, दैट फिगर ब्रॉट बिफोर माय लॉर्ड्स नोटिस, आई हैव नो केस.
अगर कोर्ट के आदेश के कंप्लाइंस में अगर 531 ही भर दिए हैं तब तो हुजूर ठीक है।
कहाँ वही को दिए ब्रेकअप
In terms of order, or it was some other order which they were.
Give dictation.
Your Lordship, the 531 posts on which the Dalpatis were observed, Your Lordship, has been as per the orders of the Apex Court. Your Lordship.
So that is the reason we are asking you. It is a newly created post, 531, in addition to the existing post.
नहीं सर, हम लोग में सर जब पंचायत का रीऑर्गेनाइजेशन समय समय पर जनसंख्या के अनुरूप होता है सर, तो
सर आफ्टर 98 you are not created any
post. 1998 के बाद
then which are the how are you going to identify 531 vacancies?
सर वो 1998 का ही वैकेंसी है सर, उस समय तक वो नियुक्ति नहीं हो पाई थी सर, और वो खींचते वो 2008 तक आ गया सर।
At that time, there were more than 531 posts which were to be filled up, Your Lordship. So after the order of the Apex Court, Your Lordship, 531 posts were kept reserved for those Dalpatis, Your Lordship. Since there was...
If 531 posts are earmarked for Dalpatis, why it was not equally distributed among the district?
Depending upon the vacancies in the various panchayats, Your Lordship, as per the requirement...
No, but to that effect, there is a judicial pronouncement.
Your Lordship...
Show us, read the relevant portion.
Your Lordship...
Read the relevant portion of the judgment that 531 vacancies were required to be distributed in this manner.
Your Lordship... Your Lordship, may I read these paragraphs, Your Lordship?
No, we want a judgment, earlier judgment, which stipulate that you are required to fill up 531 vacancies in this manner.
Your Lordship, as per the judicial order, Your Lordship, we reserve the 531 posts.
Correct. How it has to be distributed is left to you. Correct? Now, why you are not equally distributed among the every district? Because every district has a Dalpatis are working.
Your Lordship.
Will it not discrimination from one district to another district?
सर योर लॉर्डशिप, हम लोग सर ये बताएं कि जब पंचायत का सर 1993 का एक्ट आया सर, तो जनसंख्या के अनुरूप सर जो पूर्व के पंचायत से उसको रीऑर्गेनाइज किया गया, जिसके कारण सर हर जिलों में पंचायतों की संख्या घाट बढ़ गई।
Mr. Deputy Secretary, ultimate judicial pronouncement is 531 vacancies were required to be filled up among Dalpatis. Correct? Among Dalpatis or not 531 vacancies? Now why you are not distributed equally among the district 531 vacancy? Why you are left out some district?
सर 1998 में मेरे पास 54 डिस्ट्रिक्ट था सर, और 54 डिस्ट्रिक्ट में जनसंख्या के अनुरूप
ठीक है, वो हो गया। अब आपके पास 54 से घट के माली 34 आ गया
सर।
आगे आप क्या किए उसमें दलपति?
सर तो जो पूर्व पद सृजित हुआ था सर, उसमें से जो हमें पंचायत सेवक का रिक्रूटमेंट करना था सर, तो पूरे स्टेट में ये हुआ कि 531 पदों पर हम लोग दलपतियों को ग्राम सेवक बनाए हैं सर। ये डिस्ट्रिक्ट वाइज नहीं है सर कि हर डिस्ट्रिक्ट को बनाएंगे।
Your Lordship,
at least one vacancy is here.
उसको नहीं किया जा सकता। जितना वैकेंसी फाइनेंस डिपार्टमेंट जितना कर करे तो
Not amount to discrimination.
सर योर लॉर्डशिप, हम
उसमें पहले से
सर जैसे सर डिस्ट्रिक्ट कैडर होने के कारण सर
दलपति का पोस्ट हर एक पंचायत में था
सर। हाँ, हर एक पंचायत में सर एक ग्राम सेवक का पद था सर, और हर पंचायत में दलपति का कोई पद नहीं होता था सर। ये वॉलंटियर फोर्स होते थे सर, जिसमें 18 से 30 वर्ष तक के लोगों को जो उस पंचायत के निवासी हों।
नहीं, वहाँ जब रिलेवेंट डेट में वेस्ट चंपारण पंचायत में दलपति था कि नहीं?
हाँ सर, दलपति होंगे सर।
होंगे नहीं
होंगे हैं
सर ये डिस्ट्रिक्ट कैडर था सर और पंचायत वाज एकदम
हाँ डिस्ट्रिक्ट कैडर की स्टेट कैडर की बात नहीं हो रही है। अगर है कि पोस्ट डिस्ट्रीब्यूट भी तो होगा
सर।
अगर आपके पास 531 पोस्ट था वो डिस्ट्रीब्यूट होगा उसी हिसाब से। और अगर वहाँ पे दलपति थे और आपको डायरेक्शन था किसी जुडिशियल ऑर्डर में कि आपको देना था
500 सर जो हम लोग ये 500
आप एक कॉम्प्रिहेंसिव एफिडेविट फाइल करें प्रिंसिपल सेक्रेटरी लिख लिए फॉर द पार्टीज विद ऑर्डर डेटेड 1/12/2022 and 5/12/2022. The respondents were directed the Principal Secretary Panchayat Raj Department was directed to file a personal affidavit as to how 531 posts of Panchayat Sevak of the respective Gram Panchayat have been distributed amongst 38 districts of Bihar. Full stop. This affidavit has been filed. Said affidavit has been filed.
With respect to whether it is a state cadre or district cadre and whether we have...
That was subsequent order. And further video order dated 15th of the Principal Secretary Panchayat Raj Department is directed to depute in official the rank of Deputy Secretary by this board with complete papers from the date of creation of Panchayat Secretary in the state of Bihar to analyze whether it is a state-wise cadre or district-wise cadre. Further, he was directed to apprise this board that in event filling up of newly created 530 vacancies was required to be filled up from among Dalpatis, and in that event, whether combined seniority list of Dalpatis have been prepared, and whether and if the said list was prepared, whether social reservation have been followed or not. Full stop. It has further been directed that whether Panchayat Secretary post has been identified with reference to post reservation based in the light of Apex Court decision in the case of R.K. Sabharwal vs. others in state of Punjab and others. Full stop. Deputy Secretary in this and so is present before, but he not able to apprise this court about why the 531 vacancies have not been distributed
equally distributed
amongst the various districts according to their panchayat strength. Full stop. He has also not been able to apprise this court about the number of Dalpatis working during the relevant time in the state in the district of West Champaran. Full stop. Next, in view of the facts enumerated here in above, let a comprehensive affidavit be filed by the Principal Secretary of the department concerned before the next date of hearing, apprising this court in the issues raised in the previous orders as well as questions put to the councils today. Full stop. Next, list this case.
3 weeks.
Your Lordship, the appearance of
Personal appearance of the district magistrate is dispensed, but deputy secretary let him come.
My home for the treatment of my wife. She has sustained high blood pressure.
All right, next week.
Obliged, Lord.
See, now the case is for 2:15 p.m. Serial number 10, South Bihar Power Distribution Company Limited versus Bhagalpur Electricity Company Private Limited for the Christmas Sri Kumar Saurabh.
Please, your Lord's Lord, I have just prepared that list with contractual documents at one place and had Lord listed with his dates, so that every time your Lordship had not to turn out.
Give a copy to the other side.
Already given. Or I have given a copy. लगा हुआ है अब तो डॉक्यूमेंट के पार्टी Lord, your Lordship, considering that miscellaneous appeal, two miscellaneous appeal filed by the South Bihar Power Distribution Company, and one writ application, is three.
No, according to your assessment, which is the first matter is required to be taken?
Lord, in my humble submission, if your Lordship subject to, if your Lordship consider the request case, then automatically all other cases, the same issues will be there, Lord. Because the
request case number
147 of 2018, Lord. But the facts involved, it is inter-party between, in all the cases are there.
And request case, you are asking for appointment of arbitrators.
Yeah.
There are already arbitrators.
No.
Unless their appointment is cancelled, how are you entitled?
Lord, their position is that now, what is there as on today, Lord, that the term of those arbitrators, as I had earlier submitted, the mandate of those arbitrators had stood terminated. The district judge, Lord, on 29th of September 2021, that is after about more than 4 years of expiry of that mandate, extended the period for 6 months from the date of the order.
Therefore, that we first we have to decide that matter.
So then I will with that, Mr. Your Lordship will tell me here. Now, thereafter, the two honorable members of the tribunal, the presiding arbitrator and my nominee arbitrator, expressed there that they will not continue as arbitrator. And for that, now my learned friend client, Bhagalpur, has filed request case number 5 of 22 to substitute arbitrator.
Request case number?
5 of 22, the last case.
What is his prayer?
Prayer is to substitute arbitrator.
If that is the case, with the consent of your parties, we will appoint.
No, Lord, in that case, my humble submission is that neither there is this petition for substitution is Lord maintainable under section 11(6).
Alright, sir, we will appoint fresh.
Lord, my humble submission is, Lord, your Lordship will consider the judgments of the Honorable Supreme Court on these issues. Lord, I don't think, Lord, there is anything. That real party to the proceeding is the respondent number 1, SP Abel Infra Limited. That is not a party in that proceeding. The Lord representative.
He is not party to which proceeding?
That is the arbitration proceeding which was initiated by the representative, by the
According to you only, that proceedings is not existing in the eye of law as on today.
As on today, my humble submission is, Lord, that Bhagalpur Limited, the respondent in the appeal, to appeal, or the respondent number 2 of the request case which I have filed, that is Bhagalpur Electricity Distribution Supply Company, which was promoted as a 100% subsidiary of the successful bidder, only that party filed with Milord, started the proceeding. And the real party had gone behind the curtain saying that I am not a party to the proceeding.
All right, sir. Now, in view of the express opined by the arbitrators that they are not willing to continue, we will appoint a fresh.
For the Milord, my humble submission for that, that is my prayer that appoint the arbitrator and let both parties to go for the arbitration.
No, both parties cannot be, Milord. What has happened here is, Milord, kindly see, this arbitration started in 2016. We are the party therein, the whole, Milord, I'll show from the agreement that entire liability is on me for execution and the rights and liability are upon me. I gave my nomination. They, without opposing that I did not have a right to give a nomination being an agent, they accepted it. They gave their own nomination. Thereafter, Milord, the arbitration proceeded. Now, Milord, because the arbitration under the Act itself says that any objection or jurisdiction has to be given under waiver section 4 before passing or filing of a complaint.
Sir, all right. Now, as on today,
yes.
who are all willing to continue?
Out of 3, 2 have withdrawn. 2 have withdrawn, 1 remains. So that is why I have filed that those 2 be substituted by any 2 arbitrators and the arbitration will proceed.
Who is remaining?
Not only
his nominee arbitrator from
Calcutta. Calcutta is remaining. And Justice Mr. S.K. Katriyar and Justice Mr. Chandramouli Prasad has recused. And therefore, under Section 15, Milord, if any of the arbitrators recuse, then there is a provision of substitution of the said arbitrator by another arbitrator.
Why don't you go for a fresh arbitrator?
No, because this arbitration is still ongoing, Milord.
Ongoing, correct, because of these various issues.
And that is still pending, Milord. That is why they say agent or SPML. Now, Milord, the learned arbitrator in the arbitration proceeding has not rejected his condition. Milord, they say it is a matter of evidence and we will hear it in the term of final award and after laying down the evidence. Now, Milord, they are interjecting and Milord, filing a second request case saying that no, you have a separate request by SPML, Milord.
And where is the question of extension after these many years? No. Unless the proceedings are pending.
Then 18, Milord, then under 29 AF4, we immediately moved before the district judge.
Sir,
extension.
Subsisting of the arbitration proceedings, have you moved an application for extension?
Yes, 29 AF4 we moved not during existence. First there was an extension by consent.
If that is the case, where is the question of extension arises?
29-4.
Subsisting.
No. 29 AF4 even after subsisting.
Once it is lapsed, it is a fresh.
No, Lord. That is what has been decided by the courts that. Yes. Kindly see 29 AF subsection 4.
He will never agree because he knows. Your lordship, kindly see the present position.
29 AF4. I'll just answer to that query. Arbitration Act.
He will never agree for Milord the appointment of where SPML, the real party, to come in the picture. Because they are of the view that SPML, the successful bidder, remains out, no award can be made against
all
them.
This issue of extension, Milord, even the district judge has decided against them. Milord, I'll address all that.
That I am challenging.
29 AF4.
That I am challenging. That is the dishonest approach, the malified proceeding is there. The real party is Milord, your lordship permit me.
Wait, we'll just overcome this clarification.
Yes, my lord, I'll just clarify. 29A4, my lord will see subsection 4. If the award is not made within the period specified in subsection 1 or the extended period specified under subsection 3, the mandate of the arbitrator shall terminate unless the court has either prior to or after the expiry of the period so specified extend the period. So it includes both. It is the choice of the parties either to approach before or after. And this is what the Bombay High Court has interpreted, that there is no embargo. It can be done even after the
question of extension arises only if the proceedings are subsisting.
My lord will see. This has been explained in 2018 SEC Bombay Court. This provision has been explained. My lord, there is a bunch of judgments I am relying. My lord will just have a look at page 400. The language is very clear. No, sub reported. List of judgment. My lord will see page 400 of that compilation.
कौन है उसका जो आपने आप बोलिए हम खोज
नहीं, हम खोज करके दे देते हैं।
नहीं उतना तकलीफ कर रही
ये रहा सर बॉम्बे। इसके बाद
No, this is single judge. We will not.
My lord will see 29A. This provision they have interpreted.
Citation will not.
And the language, my lord will see. There is no embargo.
Correct. What is meant by extension?
My lord, it is not. My lord will.
What is meant by extension? Only if anything is existing, that is to be extended.
There is no word of extension, my lord. Kindly see.
No word extension is there.
9A4 says. If the award is not made within the period specified in subsection 1 or the extended period specified in subsection 3. So there are two situations, either not made in the original period or the extended period.
Application.
Then, my lord, the mandate of the arbiter shall terminate unless the court has.
On this point?
I'll check because as of now, my lord, I could not find whether. And neither there is a judgment which says it cannot be extended.
We don't agree with your proposition.
Lord, otherwise,
we have to read extension.
No, not just, my lord, extension is only for the purpose of subsection.
Or else it will amount to fresh time is given to the arbitrator.
Yes.
No, that is not permissible.
Lord, that is why, my lord, I see the amendment made in the proviso. That is why, if that was the extension, my lord will see.
If you have any Supreme Court decision, you please provide us.
Milord, the Supreme Court has said
otherwise,
for extension, no application is maintainable here.
Otherwise,
we have to go before.
No, I will show the judgment of Supreme Court which says that, Lord, their request case, the second request case arising out of the same agreement is not maintainable, my lord.
ठीक है. And it is not between the same party.
And, my lord,
don't try to mislead the court. You are successfully. इसी केस में आप false.
What cannot be done directly is what they are trying to do indirectly.
Both of you are doing.
They have allowed the arbitration to continue without challenging the arbitration, my lord. Now, my lord, in the fag end, when the matter was at the evidence stage.
Same time, you are not entitled for extension once it has lapsed.
No, my lord, kindly see the, my lord, that order of the district judge may kindly be seen, my lord. In MA number 635 of 2021.
That also 6 months expired in long back. That period also, after 4 years, district judge can't extend their period.
And, my lord, in any way, my lord, once, my lord, this interpretation has been given by the court, by the district judge as well, my lord will see that order, my lord, which is impugned. It will amount to deleting those words, your lordships.
Page 129. And 127.
And, Lord, this objection is for the first time being taken here. My Lord will just see.
Objection.
No, I will just. My Lord will see order, impugn order.
Right, both of you have no case. Both of you have no case. Because the question of extension does not arise. He has not challenged the initial appointment of arbitrators. We will decide. Both of you have no case.
Lord, extension, Your Lordship will just have a look at the impugn order of extension. Please just have a look at that.
Sir, we have to look into the law.
My Lord, I'll show the order and then the law, my Lord, whether this is in conformance with law or not. Please see the finding of the district.
Yesterday, day before yesterday, you are pointing out clause G. In which document?
It's a Lord distribution franchisee agreement itself.
Agreement?
Yes, Lord, pay the agreement.
132 of the compilation.
Compiled. Yes, yes, Lord.
Some
130. That is, Lord, it starts at page 132.
It is not an agreement.
Yes, Lord. D. It starts, your Lordship is come to at page 134.
Yes.
And that obligation, he want that SPML should not be here. For last 5 years, the gentleman said that I am not your distribution franchisee.
All right, both of your plea will be rejected.
Only one agreement.
Only one.
To vote. Sorry. I don't think otherwise you
Page 134 of the paper book supplied by petitioner.
Yes, sir. Page 134.
Page 134.
Don't know.
Yes, Lord.
G, how do you overcome this?
Yes.
Ask G.
Very simple issue, my lord. This is one clause, and I'll show the relevant clauses. My lord will just see the entire agreement is to be executed by me. The entire liability is on me. The payment liability, the consequential liability, and therefore, my lord, it is wrong to say that the whether or not the SPML is an agent, that cannot be decided only on basis of clause G. My lord may kindly see further. Please see couple of more agreements, my lord. Clause 5 of the same thing. Have a look, my lord will see 5.5 liabilities and obligation at page 150.
5.5
page 150, my lord. My lord, admittedly, in terms of the agreement, I am the distribution franchisee. Now please see 150, it says 5.5 at the bottom, liability and an obligation. The distribution franchisee shall accept all liabilities and perform all obligation of the distribution licensee in franchisee area in compliance with law regulations so and so from time to time. So entire obligation on me. Then next page, my lord will see again. Treatment on ongoing contract. Distribution franchisees, which is I am, my lord, shall be responsible for administering and maintaining the ongoing contract entered into by distribution license. My liability. Then 5.3.3.4 again, my lord will see. Any legal liability or any other liability on contract shall be borne by distribution licensee, and distribution licensee shall keep the DF completely indemnified in this regard. Then, my lord, again 152. My liability, distribution franchisee shall his own cost perform. So again, my entire liability. Then further, my lord, may see 5.7 at page 155. My commercial duty and responsibilities. The distribution franchisee shall perform the following, my lord. All the meter reading, collection, timely payment to the distribution licensee, replacement, everything is to be borne by me. Then again, payment. And my lord, even otherwise, so my lord, I first contend that this was basically principal to principal relationship and not an agent to principal. And even otherwise, my lord, the contention that assuming
Agreement start with part 1, part 2,
part 3, my lord, and my lord,
all the 3 have right, equal rights.
yeah, my lord, that is what I'm saying that so far as the contention that because I'm an agent, assuming for a moment that I'm an agent, and they say that I cannot move an application and the arbitration in absence of SPML, an agent cannot maintain. Lord, that is also, Lord, I've shown that the liability is upon me even as an agent. Now please see, the Supreme Court has decided that the agent can also sue and not.
No, when your name is existing in the agreement,
Yes.
you are bound by it.
Yes, so my lord, that is why, my lord, when there was therefore, my lord, when there was a dispute, we made a reference to the letter and kindly see their acceptance, my lord. That is in unequivalent term. Please see their acceptance. Lord, they have not brought it in the compilation, but if my lord will just see any of the briefs, if my lord will take the request case.
Becoming distribution.
My lord, I will show that these legal contentions are also not valid. My lord will just have a look at in MS 635. Kindly have a look at page 26 of the counter.
1 second. Other advocates need not wait. This will go up to 415. Other cases will not be taken up.
Okay, my lord will see MS 635.
Number 26.
It will be next week.
On Monday I am not here, so Tuesday. 26.
My lord, kindly see MA 635 of 2021, annexure R/2, page 24 of my counter there. They have accepted. Bhagalpur Electricity was the one who demanded arbitration. They accepted it and they never made an objection that SP Bhagalpur is nobody and is an agent, they cannot proceed. They accepted it and the arbitration began, my lord. Now, my lord will see.
Sir, we will hold, sir, that they don't have case. Insofar as appointment of arbitrators are concerned.
Now extension, my lord.
Now extension.
Now let me, my lord, adjust your lordship, assist your lordship on the concept of on the issue of extension, my lord.
For extension, you have to apprise with reference to any Supreme Court decision.
My lord, I'll just note the fact and what the provision was weighed before the district judge so far as the extension is concerned. So, my lord, we'll see. That extension petition was by us before the district judge under 29A4 of the Arbitration Act.
No, first oral submission is by whom?
My lords?
Oral submission before the arbitrators.
By both the parties. That is
on what date?
My lord, that is on 25 2017.
25?
20 May 2017.
Sorry, 25?
20th of May 2017. 25 March.
Otherwise, it was expired on what date?
My lord? Otherwise, it would expire on, my lord, 13/5/2017. My lord. Then, my lord, now they take an objection that yes, 3 months it was extended.
It expires on what date?
But then it expires on, my lord,
19/8/2017.
And then 5/8 the order was passed, after which, my lord, the arbitration expired. 5 of August 2017, when their objection were dealt with, and thereafter, my lord, because the mandate finished, my lord, it did not proceed any further. And then, my lord, we approached before the learned district judge under 29A4.
That on 5/8/2017 is what?
5/8/2017 is, my lord, their objection before the learned arbitrator for consent. That, my lord, the consent extension of time was not proper. And they said it was not proper because, one, they say it's an oral, there is no written.
It was rejected.
That was rejected.
Rejected on what date?
5/8/2017.
It was rejected on 5/8.
Yes.
Thereafter, you have approached district court on what date?
Then after August, by September, October, we filed the petition for extension.
October, September, what is that?
September of 2017 itself.
September?
Of 2017, we filed before the district judge for extension of the mandate of the arbitrator.
It was rejected on.
It was allowed on 25/9/2021.
25?
25/9/2021.
29
25/9. 25 no.
Allowed, in the sense, time was extended.
Yes.
From up to what date?
For 6 more months. 6 more months.
6 months from
Date of the
21.
Yes, sir.
It was extended.
It was extended. Then, my lord, immediately when the extension was granted, we appraised the learned arbitrator to proceed with the arbitration. So, two of the arbitrators, by their letter dated, my lord, 2/10/2021, no, my lord, on 4/10/2021, they informed me that they are not intending to go any further.
For those arbitrators?
Lord, they were Justice Mr. Chandramouli Prasad, and Justice Mr. Chandramouli Prasad,
Presiding arbitrator.
presiding arbitrator, and one of the arbitrators, Justice Mr. S.K. Katriyar, appointee of the South Bihar Power Distribution Company. Then, my lord, that is why under section 15, my request case was filed immediately, that we requested them, SPML, the South Bihar Power Distribution thereafter. No, that is on record, my lord. That because two of them have failed, you please appoint your arbitrator and we can proceed with the arbitration.
25/9/2021 is challenged in which petition?
Yes, my lord, that is challenged by them in a writ petition, in their writ petition, which is, my lord, CWJC 20350 of 2021.
GWJC है.
Now, so far, my lord,
MA 638 of 2021.
Yes.
In which the petitioners have questioned the order dated 5/8/2017.
Right.
Relating to jurisdiction.
Look, there were 3 issues decided on that order.
1 second. That we will reject.
Yes.
Because on the ground of delay. And also surrendering jurisdiction between
Bhagalpur and Bihar State Electricity Board.
Ground delayed.
It was not challenged. No, they have surrendered the right from 13/5/2017 to 5/8/2017.
Yes.
They should have approached this court in the initial stage.
That is why, my lord, even the learned arbitrator, in terms of section 4 of the Arbitration Act, says that's a waiver. That point is also taken in the order. So after that, now, my lord, the only thing remains is, my lord will see section 15 of the Arbitration Act. The substitution. What is the scope, my lord? The only scope is if two people have refrained, then my lord can die.
Arbitration proceedings itself is lapsed.
That I'm addressing. Now, yes. Now I'm addressing on the issue of lapsing, my lord. My lord, first they had said that the consent extension was not in accordance with law because it was oral. Now this...
I have not argued at all.
Very well, if they are not pressing that, then I'll address
We will not entertain that. We are going to examine only whether extension is ordered by district judge is permissible or not.
Yes. Then my lord will just have a look at the order of the district judge. 2 paragraph I will show. Lord, that is in writ number. Their writ.
Before the district judge, you have approached